right at 5 o'clock, and we're going to go ahead and take a look at the minutes from our previous meeting. If everybody would take a look at those, I will entertain a motion whenever you are ready.
I've read the minutes. I'll make the motion to approve the July 6th, 2023 minutes.
Janet Holland makes the motion. Tommy seconds the motion. Any questions or comments? All in favor by saying aye.
Aye.
Any opposition? There are none. Motion carries. All right. It looks like we have quite a few people. If you're looking to speak this evening, we're going to do this a little bit different. If you haven't signed in yet, give me just a second. We're going to swear you in, then you can sign in. Does that make sense? It's going to be a little bit of a longer evening. All those who are planning to sign or to speak, if you will stand, please.
Okay, thank you.
Charlie, they're all yours.
Thank you very much. You swear or affirm the statement you make tonight to be the truth, the best of your information and belief. Thank you.
All right, thank you very much. The first application that we had on the agenda this evening, S-2023-15, that was an application for Abbey Road, which has been withdrawn, I believe. So that application has been withdrawn. Is anybody here for that application? That would be you. Hang on before we go down that road, because we know nothing about the application, just so you know. Okay, so if you have issues with that application, you're going to have to call Joe Kane at the Planning Commission, and that came directly from Joe. Okay, so
nothing spoke tonight.
There will be nothing spoke at all.
That's our only repercussion at this point.
You got it. Sorry for that.
But it's withdrawn.
This board can't help us with anything, knowing the history that's continuing to go on.
Not tonight. Until it's a live application, we cannot, and it's been withdrawn. So as much as I'd like to tell you yes, I can't.
Right.
Basically, all we have is a legal. It's all legal now. Is what I'm hearing.
Well,
That'll be our only
Well,
avenue.
as far as this board is concerned, and the chair is correct, if it's not an active application on the table in front of them, they can't hear it. Now, that does not mean staff is not pursuing whatever enforcement, and it certainly doesn't mean neighbors can't pursue, whatever private rights they've got. But at this meeting, we can't hear it, we can't do anything because it's not properly before the board tonight, because the only thing that was here was withdrawn.
All right.
Well,
I hope you guys remember this.
and off the record, I disagree with that last statement. Because that's why we're here.
What do you mean you disagree with?
He's good. I mean, and I'm never going to ask who you're talking about, but I'm sure I know.
So he's
But this
saying all the ordinances.
is not the end of that. It is not the end of that.
That's what we're telling you.
I'm just saying, because I was representing one of your neighbors, so I'm on your side, and they can't do anything about it. They've done all they do. They withdrew the application, now it's the enforcement side. These guys are good at that, so.
No, okay.
That's a good thing, though.
I wasn't meaning to sorry for it. That's not what I was meaning. But anyway, I just hope it's remembered.
Understood.
Okay. Thank you.
All right, thanks. Anybody else for that application that wants to leave now by any chance? I can always ask, right? All right. Next application is S-2023-21. Brad Green.
Yes, this is a conditional use permit for a secondary residence for a family member located at 2609 Oxford Village Lane. It's an agricultural zone property with approximately 16 acres. Staff recommends approval of it ultimately. This is an aerial shot of the property. It's just outside of the Oxford Historic District. I do include the north arrows, so it is down is north. Anyway, Section 4.12 of the zoning ordinance lists conditional uses. Secondary residences are within it. We like to keep an eye on things, make sure that we're making sure our density standards are being upheld, and in this instance, the applicant does have a sufficient amount of acreage to request a secondary residence permit. Their location that they're interested in is on that pink star there, so it is a fair distance from the adjoining properties or any existing buildings, and we like to keep it that way, which is why I've included a condition number 6 that they just have it be 100 feet from current residences. Oxford Village Lane is a county maintained road, so if they need a new entrance, they need to contact the county road supervisor. But that's not under review right now. Ultimately, though, I mean, secondary residences are pretty common, again, for family members and farm workers. And staff finds no issue with that when compared against the regs. It's not going to negatively impact public health, safety, welfare, and it would meet the density requirements. So staff recommends approval, subject to 7 conditions. First 4 are typical 4 for conditional use permits. 5th is that they get an address. 6th is that they build 100 feet from an existing address. And 7 is that in the instance that they need a new entrance, they need to contact the county road supervisor. Besides that, that's all I got.
Any questions for Elise?
No.
All right, is the applicant here? I thought that was you.
He's getting up. I need to put on the record, that is my stepson, so I'm over here and I'm gonna keep quiet.
Wait a minute. Go on record that Charlie's staying quiet. Got it. All right.
Good luck with that.
Oh,
Yeah.
you're right, I just lied.
Yeah, all right.
I'm sorry.
Brad, anything you'd like to share to us?
Not at all. Just that piece right there, I don't want to sell it or get rid of it at all. And it's just a good spot for Ron and Casey to be and be close to Michelle. So
Okay.
that's it.
Any questions from the board? All right.
Is that between your grandparents' place and?
Of course, I'm in her place. So, and you
Okay,
know,
you live
I
where
live
your,
in Nanny's
Billy-
place. Yeah, and then
Okay,
of course,
Carrie.
Danny Phyllis's house. So it'll be on the other side of Phyllis.
Okay,
Yeah,
okay.
yeah.
Where the corn standing.
That's exactly right. That's exactly.
All right,
Yeah.
thank you.
And I did talk to Will right next door, the direct neighbor, last night, and he said, "Do you need me to come to support you or anything like that?" I said, "No." it's fine." So he's a really nice guy.
All right. Thank you, appreciate it. Anybody else here to speak on this application? In that case, I'll go ahead and make a motion to approve application S-2023-21, taking into recommendation the staff recommendations as well.
I'll second it.
Sonia seconds the motion. Any questions or comments? All in favor by saying aye.
Aye.
All opposed by the same. There are none. Motion carries. Application is granted. Thank you. You can stay around for more punishment if you'd like, but, you know,
You said emotional support.
yeah.
Just for all of the applicants here,
I think she wants
I will send out letters tomorrow with the conditions if you are approved, and then you can take that to the powers that be that are interested in it or not. It's up to you. But I will have a letter for it. There's nothing to sign. It's not like the plan commission unit.
All right. Thank you all. Next application is S-2023-22.
Thank you. This is a variance to lot width requirements. Lot width at build line for agriculturally zoned properties is 250 feet, and the applicant is requesting a variance to 226 feet. They'd like to construct a home on the property address 251 Galloway Road. It's a 5-acre parcel subdivided, as if you're familiar with the area, it was a portion of the Jeffrey Singer property at Galloway and Stamping Ground Road. And so ultimately, staff does recommend denial of this application. So this is an aerial of the property here. In '22, it was subdivided from the farm to the south for whatever purpose. It did have to go to Planning Commission because it was an item that had been previously subdivided. It went through Planning Commission without any issues and has been recorded and everything like that. It's been purchased by someone who's now interested in developing it and putting a house on the property. And given that it kind of tapers as you go away from Galway Road, they're interested in kind of centering it a little bit more on the property versus putting it in the front where the existing build line and buildable envelope is located. So this is the information. This is actually what was in the packet is actually technically to scale, which is a delightful little tidbit for us. So this is kind of the location of it. I've highlighted it there and meant to, I'm going to jump a couple of slides. I just decided to take it.
I want to know who keeps this sliver.
That's what I was wondering, why did they leave it?
To bump this up a little bit sooner. Alas, that is not the case. But when we're reviewing variances, we refer to KRS 100.243, which is our findings requirement, which states that a variance wouldn't alter the character of the general vicinity, adversely affect public health, safety, welfare, cause hazard, circumvention of requirements of the zoning ordinance, and those are kind of the 3 things we tend to base our decisions upon. If there's anything that is circumstances that are violation of the ordinance, we obviously view those with a bit of a frown. But ultimately, when we are reviewing variances, we are deferring to KRS 100.243. So as part of this review, the applicant had stated that they were interested in the accommodation due to the slope of the property. So staff did go out to the property and collect some photos of the terrain, which is this. So this is standing at Galloway Road facing the property that it was formerly subdivided from. There was a lot of brush, and I had parked my car in the other spot, so I was unable to really get a good photo. So I had stood at the driveway in Galloway Road. This is facing towards the property. You can see that there is a little bit of increase in terrain, but it's not super significant in our view. Staff identifies environmentally sensitive slopes or slopes that should be avoided for development as much as possible as 10% or greater. And after rough calculation, staff finds that while in the front it does increase in slope and then flattens out and then kind of decreases again, it's not up to that level of environmentally sensitive where we are taking extra consideration of that type of thing. This is kind of looking down and kind of seeing that terrain through the property there. This is at the electrical easement on the other property. And then this is looking towards the road. So you can see that the slope does kind of decline as you're approaching Galloway Road, but it's relatively rolling, as I've described it in the staff report. This is the slopes of the property, and unfortunately I didn't really recognize that white was not going to show particularly well against a relatively transparent background screen, but I can kind of use the other one that is more zoomed out. The areas that are darker patches are those with more significant slope. You can see that the area of this property has some slope changes and some things like that, but very few areas exceed 10%. All of the little squares are places where I was able to kind of find a house and then just mark them. So you can see that it is relatively buildable land despite having this rolling terrain. And there are areas with slopes because to the south is a creek. It's not a significant rate that would make it atypical. So when we're reviewing against KRS 100, specifically that the requested variance arises from special circumstances that do not apply generally apply to land in the vicinity or the same zone. The imagery that I've been able to find and information I've been able to collect suggests that people are able to build on this terrain without having any issues, without requiring accommodation. So staff believes that, or staff concludes that this application does not satisfy KRS 100.243, specifically subsection A. So this is my kind of summary here. And staff does recommend denial of the application. If the board is so inclined to approve the condition, as with any application, or if the board is so inclined to approve the application, as with any application, whether or not staff recommends approval or denial, I did draft up some conditions. These are our typical 3 that we see for dimensional variances. So they get their building permit, they listen to all of our rules, and then they're in good standing with any other agency or governing body's rules.
Okay. Any questions for Elise from the board?
Yeah.
All right. Thank you, Elise. Is the applicant here? If you want to come up. If you'll state your name for us. I think I know who you are, but.
I'm Scott Burke.
Okay.
And Donna Burke.
I'm assuming that was the case.
Yeah.
All right. Anything you would like to add to what Elise told us?
Well, I mean, I understand that there was pictures taken from the driveway by the road up the hill. But the thing is, when you walk up on top of the hill, it's just a beautiful flat. And it is steeper, like you can't even see the flat, you just see the hill. But up on top, it is just a beautiful flat. And it is literally steep enough, you got to put a truck in 4-wheel drive to drive up that hill. I don't want to say nobody's wrong, but in my opinion, it's steeper.
Well, and even in her report that we were sent, I know she said greater than 10 is you know, I forgot the word, but not desirable. It was like 9 point something at the center. So we're close to that line. That's where we're hoping that, you know, we can get the approval, you know, and it is, it's just sloped. And once you get there, right, it's flat. It's all the rest of it is just flat.
Yeah, I mean, you're looking at the top of, you can kind of see the top of the hill, but once you crest, it's just
The
flat.
rest of it is
I mean,
all
that's
flat.
the perfect place to build a house is on the flat. And that's what we're asking for. I mean, and obviously, you know, it's a beautiful parcel of land and we want to take care of it. And, you know, you got tractors and bush hogs and mowers and everything, you know, we got to have an outbuilding to store stuff in, and then it would have to be built down on the hill too, or in front of your house. Well, actually, it can't be built in front of the house because there's an easement for the water and the electric, so.
Yeah,
It's
that's another
just-
thing. Like on the front, we have easements for water and electric that decreases the amount of space as well.
So,
So
in our opinion, it just makes more sense to.
Well,
if
and
you know,
then
to
also
build
it
on
increases
top.
the building cost with the on the slope. That means it's more, you know, versus when it could just be pushed back a little bit to the flat as well.
This is always difficult. So we've faced these before in this county.
And we did have the builders here with us too. I don't know.
Yeah, and understand when I say this, it's not meant to be rude or anything else, but the building cost doesn't weigh to us, okay? Because as a board, we have to figure out is it feasible or not. Okay, that's the biggest thing. I sympathize with you, I do. But the land when you bought it was this, right? So
Right, and we discussed it with, I discussed the land with the seller, because it was for sale by owner. And we talked about, we even showed her, this is where we want to put the house, and which is exactly the same location. Discussed it with, when we got the plat with the, I forgot where his that exact role was, like the third party that helped us, that did all the paperwork that was with the seller. And I even specifically asked, like, what is that square on the building thing? What does that mean? And they said that was, I was told they even have it in writing, that it was a suggested area to build. It didn't mean that we would have to build there, it was suggested. So we were provided incorrect information. Our plan all along before we purchased the property was to build exactly where, I mean, because we had no idea there was any issue. You know, we go out and we said,
Yeah,
well,
I
we'll put it.
even called planning and zoning in the beginning and just asked, you know, we're buying a 5-acre parcel. It's, told them the address, you know, and said, what are setbacks or anything, you know, on that piece of land? And I was told 50 foot from all 4 sides. There's a 50-foot, setback is what it was called.
So
50-foot
that's all
setback.
we knew prior
All 4
to
ways, and
purchasing.
that's it. I asked, you know, what about the driveway? And they're like, no, the driveway don't have to be within the 50 feet. Buildings smaller than 200 square feet can be within the 50 feet, but anything permanent structure has to be within the 50 feet. So
We thought we
all
were
along
asking
we've
all the
been-
right questions.
We've been
I
trying to
think you
do
were
right
asking-
this whole time.
I think you were asking the right questions, but I think you were giving some information away from us that wasn't
Yeah, yeah.
valid. And that's the problem is, and I don't want to know who sold it to you, I really don't. But whoever, don't tell me, because we all live in this county, so I don't want to know. But whoever sold it to you probably didn't give you valid information. And now it's our job to figure out whether you can build within the boundaries that are set by planning and zoning and by the, you know, by the board. So that's what we're trying to figure out. We're not trying to be mean by any means. It just,
Yeah, we was
it's the
all
thing we got.
you know, 50 foot from all 4 sides. but
Yeah, we measured, like,
it's-
okay, it's 90 some on one feet,
We
75
measured
another.
and measured,
Great, this is
and
gonna work.
buildings, house, pool, you know, whatever we may want to do in the future.
What questions from the board do you all have?
Well, Charlie, help.
Oh, I'm not gonna talk now.
Yeah.
You're allowed back in, Charlie.
After listening to them, do we have any other recourse, or do we have?
Well, I agree with the chair, this is a difficult situation, because we tried to stick within the setbacks and the minimum widths and all that stuff for a variety of reasons. I'm frankly not so sure that this is one of the most important of those reasons, because we're not really putting in too close to anybody, the setbacks are still good. I do wish when they, not they, but the sellers or whomever had created the lot, they wouldn't have created a chunk of it, that's too narrow. That was not appropriate at the time, but that was legal at the time. After doing tons of research on slopes and all for construction for the purposes of Mallard Point and all these other places, I did not brush up on that, so I'm not even going to talk about 9% or 10%. Gosh, if it's just a four-wheel drive, though, that may well be a significant enough of hardship. I don't know. As I said, I didn't brush up on that, and I didn't try to remember all that from when we talked about it before. But anyway, it's clear they were not doing anything in violation of the ordinance. They've not taken any actions in violation and now trying to get an approval after the fact instead of permission before the fact. I mean, they're following the rules. Is this something that is significant enough that for the sake of 250, no, we're not going to allow it? This is one of those places where I think it's your discretion. If this were a serious violation, then absolutely say no. If it's something that's going to be some kind of blight or some sort of incursion on neighbors, of course say no. I'm not so sure it's any of those things. And I got to admit, if I were building a house, I'd rather be building it. But that's not a legal opinion. So anyway, I really think this falls within your discretion. You're perfectly justified to say no because it is not in conformity with the restrictions. It's not nearly so bad when it's moving back as it is when it's up closer to the road, because then you've got driveways and visibility and all this kind of stuff. Well, they've got all those things. And in fact, most of the time we're asked to cut down on lot width. It's not in the back, it's up front. Again, I don't see this one as a big one. Legally, you're utterly justified. But I think you've got the discretion to say otherwise if this is not a significant variation that does any injustice to the ordinance.
Do you think there would be any issue with some of the neighbors that have built on what is much denser or more
Steeper.
dramatic, steeper slope, because by her little gradation colored map, there's some people that have really built on steep ones.
And all I can say is they may have made some significant sacrifices, maybe not, I don't know. These are things, maybe not quite as much, well, just as much as conditional uses. They're individual determinations.
Okay.
So if the others chose to do that and didn't come in, weren't aware, we can't really take all that into consideration. We can look at these circumstances. And I think you're justified in saying no, but I think your discretion is probably justified if you were to say they've been in good faith, this is not something that does an injustice, and say yes.
Well, let's do it this way. We'll come back to you guys in a little while, if that's okay. Is there? Go ahead.
Did you receive any calls?
Well, that was my next question.
From any neighbors concerning this?
We'll come back to you. Yeah, thank you.
A lot of neighbors expressed kind of confusion and hesitancy as to we built our house on similar rolling terrain and didn't have an issue type deal. Or we didn't have it wasn't terribly costly where I'm having to carve a hole into the bedrock and then smash my house into the side type deal. A lot of them were just why did they need this? Yes, it pinches in the rear, because I had included, I'm starting to now include more visual stuff and plat copies and everything into the letters. And so they're why is it, I understand it pinches to the rear, but this property up front, is still good land, that type of thing. So I did have some calls about that.
Are any of the neighbors or anybody wants to speak of this application? Yes, ma'am. Can you come forward, please? Will you state your name for us?
Yes, sir. Terry Richards.
Okay.
I'm an adjacent owner. I'm also the seller of the property. Mr. and Mrs. Burke looked at that, and I must say that I have spent several years running my tractor and my pickup up and down that property without concern, and my zero turn. So Mr. and Mrs. Burke came out and viewed the property, took their time, looked it all over. I pointed out the suggested building site down below. I haven't really discussed that with them since that time. So I'm not sure when all those discussions were taking place. The building site is on the suggested building site is on the final plat. It's also stated in the conditions with the property that we will maintain the intent of these restrictions, and that was the plat the located building site. Intent of the restrictions that the development of this parcel be compatible with the rural setting and in harmony with the neighborhood. In other words, neither I or the other adjacent owner really want the property in our viewshed. It's pastoral. I have horses out there at 15 acres. So that being said, that is kind of the motivation for encouraging them to build down further. It is not, you folks are familiar with how the Singers terrace their property. And we're not looking at a major slope here. And I'm more than willing to give you any other information you might have.
Did this come off of the Jeff Singer property?
Yes.
Okay, Jeff owned this.
I purchased 20 acres from Jeff before.
Okay, okay.
And it's a slice of the 20 acres of mine.
Okay.
Or was mine, yeah.
Any other questions, Ms. Richards? All right, thank you. Anybody else here to speak on this application?
I'm Lou Martini with Martini Builders, and looking at the area that they're saying is buildable area, there's a utility easement going straight through that. And if that's electric, the way I built before, you have to have 50 feet on each side clearance of the electric lines. And with that going through the property towards the front, that's not a buildable area. And there is a slope up in there, and I have to put my truck in a four-wheel drive to get up that area also.
How high did you say again the electrical easement, or, sorry, the utility easement is? 50 feet?
50 feet back?
No, width of it.
According to the plat, it's a 30-foot line on center.
Okay, I just didn't see it on this little.
On center?
That's KU's easement, correct, coming out there?
On center.
Yeah.
Well, also, we're at the back of the property where they want to put the house. The width of the lot is 226 feet, a little shy of 250. At the front, it's a little bit wider, but you still have 90 feet on the left side and 75 feet on the right side from the house to the property line. So it well exceeds the 50 feet that you have to have. And they're building a really nice house. I mean, it's going to be a beautiful house, so it's, and it really does fit in that area better because it flattens out. The other way, you would have probably 10 steps up to the front door because of the grade and raising up the foundation to get up to the front door to make it level in the back. It's more of a grade than you would think difference. You know, looking at the whole thing, it looks gradual, but when you start placing where the front of the house is to the back of the house, it's a really, there's probably a good, what do you think, 7, 8 feet?
At least.
From the front of the house to the back of the house.
So I got two.
And it would just be nice to just move it back a little bit further. And they were told when they bought this land that they could put their house there, and that's the whole
We
plan.
didn't tell them.
No, you did not tell them.
No.
No. But the seller did tell them that, and the Realtor did, and that this was just a suggested area to put it in, and
When I went to get him to stake it off, he called, Marie and Associates called and said, you gotta pull it to the front. There's a little building envelope for it. And didn't know that because I didn't see it because we weren't involved in the purchase of the property. And once we saw that, we had to see that. And then again, with that utility easement,
So I'm looking at
there's really not a buildable area up in the front there.
Yeah, I mean, it's the utility. All right, thank you. Utility easement's been there when they bought it. Any other questions from anybody? Tommy? I don't think we have any other questions. Anybody else want to speak on this application?
I have a question for, so
Yes. Yeah?
that you've shown us, it does show the building envelope.
Yes.
Is this what they saw when they purchased?
I can't say what a realtor or seller gave.
Okay, but this is what was on file.
private stuff. That was what was on file with our office and is available on the plat finder. So if they're familiar with it, they can find it pretty easily by punching in an address.
Okay, and you said you did point that out to them? The seller did? I guess,
It's
yeah.
I think
sure.
it's the same item. But, yeah.
This is what was created and shown.
This was part of the purchase?
This was part of the purchase. This is what Joel put together, Joel Day.
It's in the purchase packet.
And that's what was verbalized to them. There's never been anything.
Okay, thank you. It was on the purchase packet.
The box is only an example of placement of home with setbacks. It is recorded, so let your attorney know what did, because we were waiting to do the clothing that she said, because I specifically asked about, you mind if I show you as well?
Specifically.
Hang on, I think we're heading down a road that we don't want to get into. So, from a legal standpoint, when you all bought the property, and I don't mean this in a bad way, but that's your all's issue with the seller and everybody else. That issue doesn't belong to us as a board, just being clear. Our issue right now is to figure out whether we can give you the boundary or not. I don't want to get into the civility of it. We're going to try to stay way away from that if at all possible, okay? These are always tough, and we've faced these before, so this is nothing new. We have denied these before, and there are some we've approved before, just depending on the situation. I don't have any other questions. Do you? Rachel? Charlie, anything to add? I will entertain a motion in that case.
Well, based on what Charlie said, we can use this as our own discretion, and I make the motion to approve the Donna and Scott Burke application S 2023-22.
Second?
Janet makes the motion to approve. Rachel makes the motion to second. Any questions or comments? All in favor by saying aye.
Aye.
All opposed? Aye.
Aye.
Is that opposed or approved? That's 3 to oppose and 2 to approve. Motion is denied. If you got questions or anything like that, you can always take it up with Elise and the Planning Commission, and we can revisit at some point if things change. Okay? No, it's not the easiest thing in the world, but all right. Moving on, S-2023-23, variance for the rear yard setback from 25 to 24.48, located on Hickory Grove Court, Haddock's Construction.
So, for everyone's general ease and for my sanity, we're not gonna, I've combined them into one functional presentation. I've color-coded it and separated it, because they're neighboring properties, and I figured for everybody, it just would make more sense to discuss it as such. So, proceeding if that's appropriate by the chair, do
Sorry.
you mind if I kind of combine them into one presentation?
By all means.
And so I don't have to repeat myself? Excellent.
Yes.
So
Would love for that.
application 23 is for a rear yard setback variance and a western side yard setback variance. For application 24, it is an eastern setback or side yard setback variance. Both properties are located in the Pinnacle at Mallard Point, which is an R2 zone portion of the larger Mallard Point subdivision that has access off of Cincinnati Road, about a mile south of Northern Elementary. So it is getting into the more hillier areas of town. one parcel is larger than the other by about 300 feet. That would be the property at 116. 118 is just barely, or not, depends on what you consider barely, it's just above 6,000 feet. For the application for 116, staff has kind of a two-pronged approval and denial. For the application at 118, staff recommends approval. So this is an aerial of the property. This is based off of 2019 imagery. Google does not have it in the system. We're working on that right now. So if you were to punch it in to your maps to try to find the site, unfortunately, at least from our side of things, we were having issues with it. We're addressing it from an us side of things, just to make sure us and Google are on good terms with each other. For going forward, application 23 or 116 is in the purple color, and application 24 is in the blue color, and that's 118. So when I've color-coded a bunch of stuff, I got really into it today. I was feeling really good. This is an aerial shot from 23, so 114 is built, 112 is built, 116 and 18 are appropriately next one's up, and then they'll do the cul-de-sac and everything. And I did include the whole site plat that's been recorded at the courthouse. I also have a zoomed-in one to these two properties here. While 110 has the standard for the zone, or standard for the development of a 7.5 setback on each side, a 25 foot in the rear, and a 30 foot on the front, and 116 has the same. 116 and 114 along that shared property line is a 15 foot on center storm and drainage easement. We try to protect these as much as we can, which is where the two-pronged kind of conversation is coming from. We don't want to encourage any encroachment, either through building or activity in these drainage areas, especially in areas as sensitive and hilly as the project site and the surrounding area. These are established as a means to ensure that in times of severe rain events, that the area is able to be graded to that area and then get out of the site and not cause any long-term issues with roads or with property damage or loss or anything significant like that. So that's where we kind of get our storm and drainage easement stuff from. It's going to jump on me. KRS statutes, we talked about it previously. Pretty much, we're familiar. I kind of put them side by side, which is why you can see kind of the ghost outline of 118. Where we're looking at, they're minor. You can't really tell super clearly through the 8.5 by 11, but essentially it's about a 1/2 of a foot into the side yard setback and about 1/2 of a foot or so into the rear. Staff sees these pretty often on areas where it's a curvy road. People have to kind of set their houses a little bit further back to accommodate for the curve. They can't have a curvy front house. So as a result, we tend to see these variances being required for the rear yard setback. It's not atypical, it's kind of expected, but again, given the circumstances, staff has not had an issue with recommending it in the past and would recommend it going forward. Talking about that storm and drainage easement, we want to keep people out of it as much as we can. We want to discourage development as much as we can in those areas, which is where, again, we don't like to see that. I had it stated in the staff report for 116 that if the applicant were to just essentially base that corner as the furthest side over and then get closer to 118, staff would find no issue with it getting closer. Staff understands that the lots are narrow, and because of this tapering effect from the front to rear, there are instances in needs for accommodations on side yard setbacks, and we would prefer for it to be on something that isn't going to be into any easement, utility, water line, sewer, anything, any easements, we want to keep out of those as much as we can. So while ultimately I'll talk about staff's recommendation for the side yard setback for that one, if this was to be adjusted in the other direction, staff would have a more favorable view. For 118, this is a side yard setback variance on the eastern side facing 120. Again, pretty much the same reason as I talked about before. These bends in the roads before you get to a cul-de-sac result in having to push a home back a little bit further, and these tapering effects on these home lots also result in these home models and everything getting hinched in at the rear and resulting in needs for variances. So ultimately, not atypical, but also it's for reasonable use of the property. Staff is understanding to having a favorable view on these applications here. These are where I start getting real color-coded. So for 116, these are my findings. It talks about the lot size, it's less than lot average. Talks about the rear yard setback not causing issues, but the side yard setback being a little bit more cautiously getting through that area. Ultimately, we believe that it would adversely impact public health, safety, and welfare if it was approved for that side yard variance because of that impact on the drainage through the properties, but that the rear yard didn't have any impact, so we wouldn't have any issue. So staff recommends approval of the rear yard variance, denial of the western side yard variance. Obviously, if discussion comes down to it, we can consider possibly amending to get a more favorable view, but at this time, staff recommends denial of that western side yard. 118, I would like to make one amendment to condition or finding 4. It had stated that the portion of the application for rear as opposed to eastern side yard, and so it's been corrected on the screen. Unfortunately, I did not catch it before the staff packets went out, and I'd like to make that note at this time. I try really hard to be really good about these. It's not a PowerPoint really error. It's more of a typed it up and didn't realize error, so I do apologize. But what is on the screen of that the eastern side yard does meet the findings requirement is the correct version, and the staff report is incorrect. Ultimately, staff recommends approval of the eastern side yard setback variance. Again, given the nature of the bends in the road, both items do have the same conditions of approval, which are typical 3 for variance applications.
Any questions for Elise?
Clarification, you're saying that on that denial, recommended denial for the side, if they just shifted it
Staff, yeah.
6 inches to the other side, you would
Yeah,
not have a problem with
ultimately,
them
no.
having a variance on the other
Yeah.
side?
Staff believes that there are unique conditions with that tapering effect and that bend in the road, which may warrant a variance request. Obviously, the applicant needs to come forward and talk about that one. But if something along those lines in a theoretical circumstance, and I've done this with Board of Adjustment at the city level, if items were able to be adjusted to not be in easements, we would accept accommodations on the fly and kind of go from there.
Okay, thank you.
Well, not on the fly, that sounds super unprofessional. After consideration between staff report and hearing, and at the hearing, changed your mind. But,
All right,
yes.
any other questions for Elise? All right, is the applicant here? I went the wrong side, sorry, I was over there. Anything you want to add?
Well, I wasn't really planning on speaking, but I see what you're saying about swaying the house towards the other lot line. I mean, we certainly can do that, that's not a problem. So if we do that, would that have to be a whole reapplication process, or
In other words, move it over the 6 inches? Charlie?
just to stay out of it?
I'm still trying to figure out what to put in the minutes.
I'm sorry. It's a whole lot, I did.
Because I thought I was following the staff report, and then I'm sure either one of us curved.
I tried to combine them as they were.
Well, I know, and I knew when you did that, I should have said, no, don't do that, because I can't keep up.
I can help you.
All right, 116.
116, yes.
All right, you said approve the side, deny the rear.
Approve the rear, deny the side.
You were close.
But the builder said he's willing to move it the other way 6 inches, and then she said she would not be against that.
No, you can approach on the right-hand side.
Do they need to
So
reapply?
okay. I'm sorry, we'll wait. Please,
Actually, I had it.
Where can I meet you?
16. It is approved rear, deny side.
correct.
Okay. And then I'll get to the side of the house over. And on 18, it was
Approved side.
approved side.
Side is the only one for that one.
Oh, there is no rear.
No,
No.
that one did not have an issue.
All right, now, if the house is moved over that 6 or whatever inches, what happens?
Staff, I mean, they would need a variance,
On either one or still one?
either side. If you were on the west or on the east, the house cannot sit in the existing
All right,
building envelope.
All right, so if he says yes to moving the house 6 inches, we don't even have to be here, right?
Well,
I'm the 114, that's the 116.
Well, let me understand where we are before you get in and.
Okay.
And take it somewhere else.
yes.
So, 1/16 to nice side, and approve side on 18.
Correct.
But if the builder moves it, then there's no variance needed unless 114's got a problem
Well,
with that.
there's no variance needed on the western, but it would create a variance needed on the eastern.
We're 6 inches
But
off.
we're getting out of the drainage, the
But we're
storm and
getting out of the
drainage
drainage.
easement. That's what we're doing.
I'm sorry, Charlie.
As the judge said in whatever movie, My Favorite Wife, is all this in the briefs? It better be, because that's what I'm gonna do in a minute. All right. I'll talk with you
I'm,
later. Let's get to 114 and then we can.
Okay. Oh, please. Please state your name.
This should help him.
Hi, my name's David Evans, and I live at 114 Hickory Grove Court. And I like the way you guys said, oh, it was okay to swing the house back to and get it away from the drainage, because I actually have the drainage in my backyard, okay? And I didn't want any more water going back toward that drainage, okay? But here's the real problem I see now. If the builder wants to go ahead and swing that back, okay? And I don't know why they need to readjust it anyway. These homes are only 15 foot apart. You understand? I got 7.5 foot on my side yard. And the next side yard is only 7.5 foot. Doesn't seem like anybody's talked about what we already have, okay? Now you're talking about, well, let's move the other house over, okay? But he's asking for a variance on 118 of 1.5 feet. Now, if you move that other house back over, how close is 116 going to be to 118 now if he needs a 1.5 foot variance for 118? And my question is, and I don't have a problem, I didn't come in here to create a problem. I came in here because my builder has not talked to me since we closed on the house. And I've had problems with him all along trying to finish up getting my 1 year walkthrough getting done, okay? But somebody could have walked over, knocked on my door and said, hey, here's what we're thinking about doing. And all I want to know is, well, why? And no one's ever said, well, why do you need the variance, okay? Are you building a certain house that you need the variance for on a different lot? Because I was told that the lots are the lots and they're not going to get any wider. We actually wanted to build a different model up there, but we were told none of those lots will fit that model, okay? So I guess my question is, you got 7.5 foot yards on the sides now. How narrow are you guys going to make it? And I called Elise. Are you Elise? I called Elise, and she said, well, you should attend the meeting. I said, great, because I've never done anything like this.
Would you like our seat?
No, no. But I think it's great that you guys are here and making these adjustments or decisions. But you guys approved the 7.5 foot on each side at some point in time, okay? And now they want to make it, one of them 5 foot from the, I mean, that's all the wider that 1 yard is going to be if it goes 1.5 feet, is what I'm saying. But if you shift the house, then what do you have? That's all I have. I mean, I'm just saying, I just want you guys to see the whole picture,
No,
okay?
we appreciate it.
Yeah, so,
It's just a lot to take in.
it's a lot
We're
to
not
take in.
responding,
Hey,
there's a lot to take in.
I understand, okay? And our deer are a lot to take in too, but we got them, so, just saying. Anyway.
Hopefully they're not bigger than 7.5 feet.
Yep, Charles.
Yes, please, by all means.
Put the site plan back up there again, please. First time I've seen it. With your changes. Well, I'm just saying, that's what it was, so, from 7.5, so it's okay if I put 5 inches there.
Yeah.
So if we shifted it 5 inches or 6 inches the other way, then you would be just shy of 7.5 feet on the other side, which is very minimal, right? 7 inches. Not even that, that's already 7.7.
But he's doing the cumulative shift from the other house.
Well, weren't you asking to make a move on the other side of the house too, though? On the, I mean, you're looking at the 116.
So the one next to you, yeah, would be just moving it over 6 inches so it didn't encroach on the drainage, which is fine. And then the other side would only change it 3 inches. So it's not
look and take it all in.
Close to the back.
You're close to your legal degree, so China.
I am. I wouldn't tell anybody that right now.
6.4 from 7.5, so that's about a foot, and for the house, the patio a little further. Now, we don't know what the side, that side yard is gonna end up on the next lot, we don't have that view. All these yards are maintained as one, it's just like a mowing service that we have. So all the yards kind of blend together, they're all manicured at the same time.
I wondered about that.
Yeah, I do too.
I don't know, you know, pushing 118
I'm getting
over, I'm
older.
not sure how they tax
He needs to come up here where I can hear him.
120 because we don't have that.
I'm not sure we resolved anything yet, but you know.
Well, I'm not trying to, I'm just saying, okay, well, I didn't want it to encroach over toward the, where the storm drain was.
Right.
Okay, that was my main concern, was the encroachment of the storm drain and not wanting to have any more going down in there, okay?
Till we
But
take that
I just don't want the lines, I mean, I don't want the yards to get any smaller between these houses as the developer goes down the road, okay? And I don't know why that would be, okay, unless he decided to try to build a house somewhere that, is he trying to find a wider lot somewhere to build a house? Has he had somebody come to him and say they want to build a house and we'd like a wider lot? I don't know. See, I don't know because no one's been knocking on my door and asked me, okay? So, but I mean, me as a concerned resident, you've got a 15-foot yard between the houses now. Let's not make them 13-foot or, you know, smaller.
Well, the lot size is not changing. We're just talking about shifting the
No,
house.
but if you move the house closer, I'm not saying, I didn't mean lot. What I'm saying is if you move the house closer though, it's gonna be closer to the next house, okay?
And
So
farther
you're
from the
gonna
next
have, the width between the houses is what's gonna change.
I think for me, in this position, the most important right now is the drainage.
I agree.
Okay, so taking that into account, if you look, I would rather not back up water. I'd rather take up a little bit of yard space and not back up water and flood everybody's house or whatever the case may be. And that was the purpose of this, was to move it back over away from that drainage. So
Now, what was the reason for moving it back? Because it, well, okay, so you're keeping it even more away from the drain, that's good.
okay,
Yeah,
I'm going with that's good.
But I see because of the curve of the yard, that's not gonna be
You had the math?
Okay.
I did not do well in college. That's not the point.
Numbers? Come on.
Numbers who? I don't understand. Okay, this is gonna get real into it. I'm sorry, Charlie. I will help you with the minutes at a later point and triple check everything.
Even get me back on the subject.
So, if the home was moved over to allow to put the back corner of that porch at 7.5 feet, that would require essentially moving it by 0.53 up a foot, so just over 6 inches. So you move that over 6 inches. There's a little bit of give on that eastern side facing 118. If this is pursued and they do pull it off that drainage easement, they do have to get closer, at least with the home model that we've been given, be closer to 118. Instead of being at 773, which is where it's at right now, it would need to be 723. So it would be a variance change of about 3 inches, 4 inches.
Which is what you
So it would be negligible, relatively speaking, to find that difference when you're looking at a large 1,600 square foot house or something like that. I don't know why I chose large for that word. Some people would argue that that's not a large house, but I live in an apartment, so it's very different. I'm used to small spaces. But ultimately, it would just inch it a little bit closer to 118, and then 118 would, staff had no issue with 118 being closer to 120 in that theory.
But we can worry about 118 and
When they come up to it, these ones are not items, since they're not items on it, that's negligible what the condition is of 120,
Yeah.
if 120 is even gonna be built on. So we're really just concerned about 116 and 118, and,
Any other questions?
so I have.
We agree, by the way. Okay.
I think that's
Yeah,
an
yeah.
excellent way to end us.
Yeah.
I do apologize, Charlie, for the minutes, because it will be all hodgepodgey, but ultimately, staff would, if the applicant is agreeable, and I'm not putting words into it, what collecting everything is, it would just be a eastern side yard setback variance on 116 from 7.5 to 7.23.
Yeah, because you don't need a setback variance now for the, I guess that would be the western side, right?
No, it would be
Correct.
eliminate the western, have another eastern. So it'd be eastern and rear for 116, still eastern for 118.
Is that right? You agree with that?
Based kind of on summarizing what conversation has gone on over there and
So-
doing some math, that's where we, at least that's what has been discussed.
Charlie, did you get that?
Charlie's expression is pretty.
Because that's going to amend this application.
So there would be no encroachment on the west side of 116.
Correct.
There would be a,
Encroachment on the east side of 116,
And what does it go to?
7.23.
3 inches.
yeah, basically a quarter foot.
Yeah.
Okay.
Yeah.
So let's get this one locked down.
All right, so let's stop at 116 for a minute.
Yes.
Let's go ahead and make a motion on 116 so we can get it out of the way, since we're talking about inches at this point. So I'm going to make this attempt, all right? I make the motion to approve the conditional use permit for what is the, I don't know the
How do you
application number.
pronounce
S 2023-23, approving the variance of the rear yard setback from 25 to 24.48, and then amending, correct? We're going to amend, because we don't need the western side yard setback, but we're amending to an eastern yard setback to 7.23 from 7.5. Is that correct?
7.73.
No, it's a,
Well, that's
Yeah.
7.7 is not 7 and 0.5.
we're amending to 7.23.
Yes, we are ending at 7.23.
All right, so the motion is to 7.23, taking into account staff recommendations. Did you get that, Charlie?
I have it written down. It's fine.
I'll second it.
All right. Actually, Sonia seconded before you did. Any questions or comments? All in favor by saying aye? Aye. All opposed by the same? There are none. That motion carries. All right, now let's move on to 118, which I believe this one's fairly easy.
This one has been unamended per
Okay.
conversations.
In that case, I make a motion to approve S-2023-24, taking into account the staff recommendations. That will need a second.
Second.
Rachel seconds. Any questions or comments? There are none. All approved by saying aye.
Aye.
Motion carries.
Y'all are exhausted.
Yeah. All right.
It's very detailed.
All right. Did we get all that in? You guys are, okay, good.
Yeah, Saturday night or Sunday, I'll call you.
Yeah, go ahead. I'll make sure I answer that.
Let it ring till the end,
Yeah.
Charlie.
All right. These meetings get longer and longer and longer, not shorter.
Our hour's up. Our hour's up.
We're gonna have to have a seminar on how you do that there.
I'm trying. All right.
And then like the minutes, the meetings went from 45 minutes for 6 applications to 45 minutes for half of one. And so it's shifted a little bit.
All right. Next order of business, not even sure how to bring this one up. Scott County Board of Education. Scott County Board of Adjustments. Joe Kane had sent a letter to Turf Masters for the conditional use review. I think that's why we're all here, which is our last thing. So Elise, do you want to start this one off?
So basically, what we are returning to is case S-2022-47, at which, in that meeting in December of '22, a conditional use permit for a commercial landscaping business was approved at 2461 Frankfurt Road with in total 12 conditions, 2 of which were added at the meeting. This property is west of Robinson Lane. It should not say denial. It should not say 5 acres. I meant to pull that thought. I did really well with this PowerPoint. I'm so sorry. Please disregard those comments related to denial or acreage. For everyone's sanity, just don't look at it. Close your eyes. So this is the property here. This is an aerial that I used at the time of the Board of Adjustment application. I'll kind of run through a little bit of the timeline, set a little bit of the stage, and then I'll come to why we're here. We can hear testimony on both sides and go from there. This is the property. That's the Elkhorn Creek. And that's a north arrow to the right. Yes, to the right. So my timeline, this is across 2 pages. Commercial landscape business application was applied for. Staff reviewed it on the 1st. It was approved with 2 additional conditions that I can get to eventually. They worked on a development plan, and in April they filed for the March 9th meeting of the Georgetown-Scott County Planning Commission, at which meeting it was approved with, I believe, 7 or 8 conditions. Can't remember that one exactly. You have my PowerPoint slides, you can tell me. After which, we kind of operated pretty cool for a little bit, and then we received some concerns from neighbors on the site operations related to nuisance stuff and objects in the floodplain. Our director did go out to the property and issued a FYI pretty much, or a please get this out of the floodplain, it's dangerous, notice to the property owner, and we moved on. May 3rd, we received additional conversations and complaints from property owners, and the director issued an interpretation that the applicant could not haul landscape material and construction debris and burn it on the site as part of the business operation. And that at the time you were reviewing the final development plan, they'd collected all the signatures. His was the final signature we were waiting on, and he had stated that he was going to add a note to the plat that the burning of refuse and everything sourced elsewhere would not be permitted on the site. The applicant had returned comment and said, wait, we'll discuss this amongst myself, we'll get moving forward with additional time. So from May until July, additional time was given to kind of address these issues and everything like that. After which, around July 10th, the director reached out to the property owner saying, hey, it appears that conditions have not changed, or we haven't heard anything from you. What's the plan? At which the applicant had contacted an attorney, or had an attorney on retainer at the ready, and in conversation with the director, determined that they discussed amongst themselves and did not object to bringing the application back to the board for clarification. Where we sit right now is the determination on whether or not the conditions of approval, the 12 that we approved in December, have been adhered to, any of them. The specific 2 that the director references, I did put the whole presentation in here for my convenience, and I did not help myself. Come on. The 2 additional items relate to sightline boundaries and site operation hours. However, other conditions are the 4 typical ones we see for conditional use permits. They obtain building permits if they're going to be building. And then 6 that were included by staff, which relate to junkyard operations and what, as defined by the ordinance, that they keep all materials, machinery, and vehicles a minimum feet of 50 feet from property lines. They submit a preliminary and final development plan. They keep all vehicles outside of the floodplains, as well as materials and machinery, and that they have a planting and fencing denoting floodplain installed along front floodplain line in accordance with the commission engineer. Ultimately, I believe that was some kind of light tree plantings and maybe a fence. I cannot exactly remember. I have the full-size plans with me if we do need to reference them, and they were included in the staff packet. And then our 2 additional conditions. So after it went through all of us, and we had all these discussions and items, and I had to read Darren's very difficult to read handwriting when he added those conditions, related to sightline boundaries along the west property lines after concerns from neighbors were expressed, and just trying to keep to regular business hours as opposed to operating outside of, or not outside of, but later in the evening, earlier in the morning, or on the weekends. Now we get into our application to the Planning Commission, which was heard in March of 2023. This is the slide from it. They requested and received a waiver for gravel parking on the property. We do see this in businesses that are in agricultural areas. Oftentimes drainage and kind of appearance of properties, putting a big old concrete slab is not super reasonable, and so applications will come forward, such as Triple J Farms, which we had seen previously when they did their farm stand operation, and other places that I can't think of the names of. They have requested gravel for vehicle parking. This is the slides for that. This is the preliminary development plan with the floodplain noted, and it shows all of their little tree plantings, their little vehicle use area in the existing building. And then I noted all the landscaping. So orange is the trees that are kind of UA trees. The additional smaller trees are in blue on the west side, which would be your guys' left. Everybody else is also left. Not mine. It kind of is mine. And then areas of existing tree canopy that were going to be retained. Ultimately, the Planning Commission Board did approve the application for preliminary development plan approval, subject to our traditional 8. Thought it was 7, it's 8. Mostly, these are typical items that we see. So they get development plan approval, they do stormwater management stuff, they get their species-specific landscape plan, it's valid for 2 years, et cetera, et cetera. And we do have, at least on the plan that is included with the staff memo and in the staff packet, it does include that development plan, sans the signature from our director. So now we come together and we say, we have these reports from neighbors and everything like that. Is there an instance of potential getting really close to the line or crossing the line where a condition is not being followed? Is there a condition that needs to be added or amended based off of concerns from either side or so on and so forth? And just overall, we're just trying to clarify, is everybody in good standing? And that type of thing. As kind of expressed by Joe's memo. Unfortunately, he is out of state right now, so he is not here to speak on any of his points of view, but we discussed it amongst ourselves quite regularly in preparation for this meeting. So I feel like I've done a pretty decent job talking about it.
Any questions for Elise?
Not yet.
I will
Yet.
put a pin in it. I will.
Understanding that everybody is here for this, so let's make sure we keep this precise and not emotional by any means. So if facts are facts, right? So I'm assuming, applicant, you're the attorney?
Yes. Good evening, ladies and gentlemen. My name is John Woodall. I'm representing Mr. Franklin and Turf Master. I think this is, Elisa's right. I spoke with Joe about this. I wasn't present or representing Mr. Franklin when you all heard this in December. This really isn't that complicated. What happened is, yes, Mr. Franklin was approved here. This was heard at a lengthy hearing. I went back, I've watched the transcript twice now, and the issue of burning and debris was not only discussed in Ms. Kretz's report that was before the board, but also on a few different occasions at the hearing. Most of the time in your hearing was spent talking about sight distance and the floodplain. There was admittedly very little time talking about burning, other than Chairman Dillo asking the question about the brush pile and what was going to happen to it. And the response from Mr. Franklin was it would be hauled away or burned, because burning of landscape debris, woody material, is integral to any landscaper's business, especially after the cold snap we had here in December and all the storm damage we had. No construction debris is at this property. It's not an open dump in terms of the definition where you can haul in things there for a fee. So what happened was, once Adam gets his approval here, then he goes to the Planning Commission, he gets his preliminary development plan approved, and then he's done everything, he's got his final development plan approved, and Joe wanted to add a condition because he'd gotten complaints because that burn pile, or the brush pile, had in fact been burned. Took 2 burns to do it. Should have moved it out of the floodplain before he did it, but just burned it in place. Some of the material, if you recall, was there when he bought the property, and then some he added to it. In the future, if he burned anything, he knows he'd have to be out of the floodplain. But Joe gets those complaints and then wants to add a condition to the final development plan that you didn't add here to yours. And the condition was you can't haul any debris into the property and you can't burn any debris on the property unless it's your own. You didn't say that. And it's impossible to run a landscaping business with that kind of a restriction. And nobody else in the county's got one. And there was some discussion in Joe's memo, and Joe does a great job, about the fact that this could be against the state statute, burning or hauling stuff in there. I would submit to you, I'm not aware of any enforcement action by the Energy and Environment Cabinet in this county or any other against a landscaper doing this. But as far as the other conditions, the way I've understood this proceeding is we weren't reopening the record to talk about everything because you've already done that. But I don't believe there's any allegation other than the fact that these materials that were in that area and he added to it in the floodplain, that burn took place. It should have been moved out. Just doesn't make any logical sense to have done that. In the future it will, because that's the restrictions. But other than that, I don't believe there's any allegation whatsoever that Adams violated any of the conditions that you imposed. He's not shied away from doing any of the work that's been required in terms of screening and so forth. And I could argue about it all day long, but frankly, what he wants to do is just be a good neighbor, get along, do what this board wants him to do. He's fine with putting up, say he can only burn this debris once a month, if that's what it is. And we know it has to be out of the floodplain. But we really don't want to make this something it doesn't need to be. Y'all have heard enough about this. You've already approved it. But the reason why we're here is because staff wanted to add that restriction, which is very onerous. And even though burning was discussed, and I believe Ms. Kretz even said in her closing remarks that you all put conditions on these types of establishments before regarding burning, meaning you can do it so many times a month or whatever. I won't put words in her mouth, but that's fine. We can do that. We just want to kind of get on.
Yeah, thank you.
All right, thank you.
I know there's quite a few folks over here that want to speak. Who wants to go first?
Chairman, are we talking about everything or just burning?
Everything can be reviewed, right?
So under Joe Kane's letter, everything can be reviewed.
Okay.
By all means. Did you say we don't care? I do have good hearing. I can't hear that.
Rick Jordan, 280 Robinson Lane, half a mile or so down the road. It's my wife, Kristen Chilton. Her complaint was she didn't sign the list, but I'm not letting her get off that easy. Apologize if I'm out of order. I guess our biggest concern is the smoke. We live along the creek, and the smoke travels down the creek. In the evenings, when it's the dampness, the smoke banks down in the yard. The first couple of times it happened, I'm outside walking around my house looking at my gables and eaves thinking one of our buildings was on fire. Because anything that is open, garages, stores, it just fills them with that smoke odor. And I think I know what that smells like.
I mean, we couldn't have our windows open at night.
Yeah, if
That's
you
how
had
bad
your
it
windows
was.
open,
I mean,
it would run you out of the house.
And he did, just to add to what Mr. Goodall said, when he first started burning, it was a lot, and it was days and days and days and days. It wasn't just a quick little knock it down in a day or so. It was it burned overnight, day after day. And we lived downstream, so it just naturally smoke went down and just kind of went all the way to the end of the lane. We live right across from Robinson Dam. So that's a majority of what our personal complaint is. guess I have a question, just out of curiosity, how long is this conditional, like, how long does the person who has a conditional usage permit allow to finish the work?
That would be the site development plan, I believe, but.
So how long does it stay in the conditional phase? So, because I mean, burning is our primary, but I know as far as some of the other neighbors are concerned about the plantings, and so how long does somebody have to complete that work to where it's signed off on?
To kind of talk very generally, preliminarily, conditional uses are active on the property without expansion or change or anything like that under whoever was the owner at the time of application until that owner sells the property or a permit is revoked or it's extended contracted or it's not active for more than a year, after which it kind of dissolves itself.
So if they don't do anything within a year, then it's,
If I'm not mistaken.
You're asking about the plantings, though, meeting the conditions, right?
Yeah.
Right, meeting the conditions, so how long can that be stretched
how
out?
long do they have to finish it,
Right,
basically?
that's, I guess,
Yeah.
of all the
Putting in
things
their-
that
putting
were
in
put in
their trees and
the,
stuff.
in the conditional listing, all the things. that
Yeah,
we
it can't drag out
listed,
20 years, that's
right,
what you're
how
asking,
long
right?
is that till it's closed and you go, wait, you didn't complete your work?
We're all
and
looking at you, because we,
I was just curious, I'm just asking for educational.
Well, I think it's a little more specific than this. We just recently told a developer that got permission, all of a sudden this is in the city, 2 months ago, that yes, this fence has got to be built before you go on with your business. So, I mean, it has to be timely. Now, if there's a reason, obviously with reasonable justification, of course, we're going to extend the time to do, what you need to do. But it can't just go on and on and on for no particular reason. Things need to get in place, and they need to do what's actually been approved. Now, we don't usually tell them you got 30 days to do it, because, we try to operate in good faith, and we expect them to. If it doesn't appear they are, then no, we'll give them a deadline. If there's a reason for the delay, well, of course, we'll go along with that if it's at all reasonable. But otherwise, no, conditions, if you have a condition to meet before you do something, then you need to go ahead and meet the condition.
Condition, okay. That was my question, is
Yeah.
what the time frame, because you saw the timeline, and it's been a while. But back to the burning, you can drive out there right now, and there's a huge pile of debris to be burned, and it's in the flood zone. There's no doubt about it. I mean, and I know Mr. Franklin hasn't been there when all that area is flooded, but we have been there when that area has flooded. And it's hard to believe that Algonquin Creek gets as out of its banks as it does, but it does. And
I believe it was 2017, the water was up, maybe in the barn, if not up to the bottom of the barn. And the floodplain maps have been upgraded, I think probably twice in the last 10 years, or at
we
least
lived there.
upgraded one time in the last 5, 6, 7 years. So they keep moving those lines. I mean, to me, it's a tough piece of property to run a business on. I mean, it's a very limited area above the floodplain. And I understand the floodplain because most of our property's in the floodplain too. And like Kristen said, that pile of brush that's here now is as big as a house. It'll burn hot for, my guess is 12 hours, and it'll smolder for 3 weeks.
All right.
That's just the way that is. And I know some counties around us, they prohibit burning, they grind the stuff, and I think air quality recommends that. They also recommend not burning in floodplains. I don't know where it could be a burn pile on that property that wouldn't be in the floodplain.
or that can't be sit there and burned unattended. I mean, it would just be sitting there in the middle of the night just burning.
Okay.
That's.
All right. Thank you.
Thank you.
All right. Who's next?
You all have seen me before.
Can you state your name for us?
Yes, my name is Zoe Zamora. I'm at 131. I know that there were primarily 2 points of conversation today, and that was number 2 and number 9. For me, I wanted to draw attention to item number 2, number 6, 7, 9, 11, and 12 as far as the conditions go. Number 2, I know that has already been addressed in the memorandum. Bonfires, as they mentioned, have been set and left unattended overnight They are also very close to my property line, and we have trees that are very close to where that bonfire is. They have been left unattended, completely unattended, with flames higher than my height, well higher. And it's been very concerning as a person that owns a log cabin to have a fire of that capacity near where I live. I wasn't sure if it was illegal or irresponsible to leave a fire unattended, but I mean, in my experience, and I have an extensive experience in adventure leadership and doing all things outdoors with Leave No Trace and a number of those kind of things, I've never left a fire unattended, especially one of that capacity. They have been left to burn for days at a time, leave the area really smoky, and I have also had experiences where early on, unnatural type materials were being tossed into the fire. I don't know exactly what those materials were, but I know that there were large booms that were happening. I had company over, and we both heard explosion sounds, and we went outside, and then they continued to happen. That indicates to me that there are not natural items that are being put into the fire, which I know is definitely against code. And that was also well after 5 p.m., which is outside of the normal parameters. Number 6, it has been really unsightly. There's just large piles of debris. There's always vehicles there. It looks like a parking lot. It's not a peaceful, serene type environment that you want to look at off your back porch every day, you know. I also believe that the bonfire is not more than 50 feet from the edge of the property. When standing on the property line, when triangulating with the red or the orange cones there and indicators, when the fire was burning, it was not standing on my property line. It was not, I couldn't get close enough. I couldn't bear the heat from my property line. So I do believe that it is less than 50 feet. For number 9, there are consistently materials in the floodplain, whether that's vehicles or piles of debris or different landscaping type materials. It's consistently. Anyone that drives by, you can see that it is always in the floodplain. As we talked about in the very first meeting, there's only 0.8 acres that are not in the floodplain, according to the graphic. And that's not where you can see that in that yellow section and sometimes the purple, there's always stuff there. So, 11, as far as I'm aware, none of the sightline boundaries have been put into play. It was my understanding that they would have to be put into play before business was conducted, but I have read back through those and I see that it doesn't say before, so that I think is another reason why I wanted to know what those timelines look like, how long he has in order to actually have those sightline boundaries put into play. There are always noise concerns. We hear the trucks and the dumping and everything else all day. That leads to number 12, which is there are workers present all hours. It is definitely not between the 8 and 4:30 time frame that was allotted. Sometimes there are people out there sawing or dumping at 9 o'clock at night. It's not a peaceful environment. You know, I'm sure that there could be an argument coming up that, you know, I haven't communicated with the owner of the property, but at no point have I felt comfortable or safe to express any concerns as I am actively being said, that's not true behind me. So, and shaking head, bulldozed, is not a healthy communication style. So, there were also, just to circle back to the Woodall comment, materials were not present at that burn pile where the site is right now. So that was just not a fact.
Okay.
Those are my concerns.
Thank you. We'll just go down the line. Who's next? Anybody? please state your name.
My name's Tammy Nolan, and I live on Robinson Lane, and I just have the two concerns. One, there was foreign debris in the burn pile. The burn pile's in the floodplain, and there's vehicles and equipment parked in the floodplain. Construction vehicles leak oils and stuff, and my concern is environmental. That I don't care for that to be washed into the creek. We love the creek, and we want to preserve it. So those are my only two comments.
Excuse me, your name again?
Tammy Nolan?
I don't see you signed in.
I didn't.
Oh, did you swear?
I swear. Did they swear? Did he swear? He didn't swear.
Everybody.
I swear. I swear really bad sometimes.
The first name again was Tammy, did you say? Yes, sir. Okay, thank you.
Can you come back for a minute, please? So, and Charlie, keep me in check here because I don't want to walk outside of my boundaries, but this property is very visible to everybody in this county. He's sitting right on the road. I pass your property almost daily, okay? So I don't live far from you, just so you know. I don't live far from you all. I know most of you all, and I know who you are, okay? So this county is very small, right?
Yes, sir.
The burn pile you have, it's large. Not a doubt about it. I'm sorry, I'll address you. I shouldn't address you.
No, it's okay, go ahead.
But the burn pile is very large.
Yeah, I've seen it.
It is most definitely in the floodplain.
Because he hadn't,
Not a
hadn't
chance
burned
in this world.
anything since Joe put him on notice of this. That's why it's.
Understood.
You're
I
right.
think, and this is purely a question, it's not a comment or a statement.
Yes, sir.
But I think, and correct me if I'm wrong, there is a statute or a law in the state of Kentucky about bringing outside waste to burn.
Yes. Which reg?
Can't quote it. That's why I said it's a statement, okay?
Okay,
So
yeah.
I'm not going to pretend to quote a reg because I don't know what it is, but I believe there is. Charlie, is that correct?
That is correct. I can't cite
I can't either.
regulations, but yes, it is prohibited to bring it in. If you create it there, you can burn it there.
Correct.
But you can't.
Unfortunately, my background is heavily in that, okay? So I know it's there, and I'll get it for you, but I know it's there. That's a main concern for me, is bringing inside the outside debris to burn on property.
Right.
Okay, so
Yeah, I understand. I understand what you're saying. It's a matter of interpretation. How does the state interpret it?
right,
And in terms of enforcement?
yeah, fair,
Because it's happening
fair.
in every
Okay.
county.
That's why I said your client is extremely
Right.
visible on the road right now.
Right.
Okay, so
Exactly.
understood. All right. So I'm not saying anything about that. What we're here is burning, okay,
Yep.
which is causing a nuisance. Yes, we did talk about the burn pile. It was down at that time, I believe, even closer to the creek from where it is now. However, it's still in the floodplain now. How do we address that?
I think it's got to be, what I heard is, first of all, that's what I was asking Adam about, the pile that's there now, before it would be burned, it's got to be moved out of the floodplain, number one. Number two, he says the fire's, he's there himself, not left unattended when there's upward flames.
No flame.
Hang on, before we all
So-
react. Hang on, just stick with us.
So that's the second thing that can't happen.
The foreign debris bothers me. Foreign debris in a burn pile.
Never, it's always natural material, always.
Okay.
If there was something.
Have you been there?
Hang on.
While
Hang-
he's been burning it?
Hang on, hang
Have
on.
you gone through the pile?
Time out.
I mean, I don't mind opposition, but.
Time out. Hang on.
Let's be truthful.
In there from like, let's say I go cut a tree for Mr. Perkins, and walking up that tree, I rake up a Snicker bar wrapper. It goes in the trailer. When I get back, if I see that, I remove that. It goes in our trash. It's all natural material.
Have you ever burned any 5-gallon fuel buckets, anything that would explode?
Never.
Okay. I'm going to skip that point for a minute because I don't want to create a ruckus that we don't need to.
Yeah.
So the burn pile is a concern. Okay? The other one is the sight lines that I don't believe are up because I drive by that every day. Okay? So obviously I can see it, but this is coming from me personally sitting on this board. Okay? I'll let the other board members speak to what they think. That's the two that I feel are pressing right now.
And I understand, because the final development plan was not signed off on by Adam because of the condition.
That's fair.
That's placed on it. What type of plantings are you doing to meet the sightline requirement?
Once the trees are become available from nursery that were required by the state of Kentucky, that you guys use, or Scott County uses University of Kentucky's planting guides, I know them well. In order to get all those plants that I need, I'd like to buy them in a bundle, be able to do that, and we do it in the fall. I couldn't do it this spring because we were trying to do the fence I put up, the gravel we put around, all the other stuff. So it's not gonna take a year or anything like that.
Right.
It'll be in 2 months.
And understanding the development plan wasn't signed until.
And Mr. King didn't sign a plan, he wanted to add a handwritten note in there, you know, no hauling debris or burning, handwritten. And I just didn't think that was fair to the board for him to do that over what you guys would decide. I just didn't.
Anybody else? Give me just a second. Anybody else?
I do have one question.
Yes, ma'am.
Okay, so we are hearing that the fire is being left unattended, and you're saying it's not. So are you personally staying till the fire is out?
I stay, or my cousin who's there with me burning. We burn, the 2 times we burn here, I would stay there until the end of the burn, and we would hose it off with the water hose that I have right there beside. Actually, where the original burn hollow was, I trenched and put in a water spigot to be able to put that fire out whenever I need to because of what was currently there.
So you're putting it out at 4:30?
In the afternoon, whenever we let. As I understand, I'm able to stay there.
You are able to stay, your cousin's not. That's
I
why.
can stay there, he's not working for me.
Yeah, as long as he's not employed.
He's family.
Oh, see, that's it, that's a loophole.
There's a lot of us in Scott County. Standing there.
Yeah, so employees.
4:30 in the morning sometimes.
Trust me, the employees want to get out of there as soon as possible.
Charlie? You knew this was coming back.
Oh, sure. Well, I think the primary thing to be considered is whether or not, you know, the conditions are being followed. And I got to admit, I've got a real quandary at work, because we talked about the fires, and frankly, I can't remember now why that wasn't expressly a condition. I know part of it, and I think I discussed this with Mr. Woodall earlier. Part of it might well be my recollection of earlier hearings before me about this property, about there's not going to be a need for all this burning.
Right.
Well, and that may have been the Oxford, whatever road. I was thinking it was this one. But regardless, it's not a condition. On the other hand, the conditions do talk, and I'm afraid too generally. Where is it?
Number 2.
Keeping materials and all that stuff in a manner that's not, you
That's
know,
number
nuisance
6.
and whatnot. Well, good Lord, bringing in debris and burning it. But at the same time, I understand that that's part of a landscaping business. So that's just something that I think needs to be dealt with specifically. A generic kind of condition is just simply not sufficient a lot of times, and I think that's not sufficient. I'm not sure what we do when it comes to burning things that are brought in, because state regulation, and I read it over when Joe first contacted me about this, before I talked to Mr. Woodall. And I also understand the fact that there are regulations the state doesn't enforce, just like I know there are certain regs that local enforcement folks, you know, may not enforce either ever or sometimes, you know, periodically, who knows. In fact, I've got them in my own neighborhood I'd like to see something about. But it bothers me that this is a clear violation of a very specific state regulation. And in fact, if those things are to be burned, well, if they're produced on, you know, 100 Cosmic Lane, then they need to be burned at 100 Cosmic Lane. They don't need to be brought in and burned somewhere else. On the other hand, I understand that that's a serious part of landscaping business. Maybe that's why my yard is bare, because it's just too difficult. So, you know, I think the board needs to, you know, I think they need to tighten up their conditions. I'm not so sure, just from looking at the reference in the agenda, that proper notice and all for that is actually for today, which bothers me. When Joe and I talked, and I'm sure I just kind of took things in general, just like I'm sure he did too when we talked about it. It really needs to be an enforcement letter, not just simply, you know, administratively give us some advice, It needs to be an enforcement letter that says something based on the conditions that we actually have. And then he can bring this thing and say, come back here. Or the neighbors can come in and say they're not being, followed. Enforcement letters, stop work kind of thing, or stop violation kind of thing. So this is just a little too amorphous, for me at the moment. But I think what would be helpful if we could do this is if we could work out what the conditions ought to be, see what the response, both the pros and the cons. Although, God, that sounds like a much longer time than I'm going to put off supper. But I think that's the way we kind of salvage this, because otherwise the proper thing to do is a stop, the violation order, get specific. He either comes in with a plan on how he's going to deal with it, or things he doesn't feel are appropriate. He can file an appeal of that. It gets back to us. So I mean, this is just a little too loose. Unless we can sit here and work some of this out, put it in writing, hopefully get a signature on it of everybody, and like I answered earlier, no conditions can't just drag on forever. Planting in the fall, so that frankly makes a lot of good sense. Because good Lord, you plant something in the month of July, it's not worth anything. Usually, it certainly wasn't in our July, and maybe not back when we were getting all those torrential downpours either. I don't know. But burning in floodplains, of course, got to stop. Burning huge, frankly, I think that's got to stop. Because those things really ought to be taking place where the stuff is created. Because otherwise, we're giving permission for people, which we cannot do, to violate state regulations, which they may or may not enforce. But we simply can't say, oh yeah, sure, you can do that.
Right. We know they exist.
I mean, we just can't do that. We can't even appear to be sanctioning illegal behavior.
I have a question for you, Charlie.
I think I've already gotten deep enough in the hole.
No, I mean,
What do you want?
I know that like when we grant conditional use and then we tell both sides it can be brought back up for consideration, whatever, down the road if there's complaints from the neighbors.
Not just if there are violations, but even if there are conditions that we didn't deal with that appear to be appropriate because of, the way things have played out.
Because we're seeing things we didn't see at the time. So that means that when you're saying clarification, and we're also looking at clarification or addition of conditions based on what we're seeing today.
But that's why I wish there had been an actual enforcement letter.
I understand.
Not asking for advice, because that's really not what we're supposed to do. We're supposed to have applications and oppositions or questions and answers, and appeals. But we really aren't supposed to just come in and discuss and work. I mean, that's not exactly what's supposed to be in front of us.
Okay.
I think that's what's needed right now, and I'd rather do that right now if we can, than start all over again and end up doing the exact same thing just
Agreed.
because we follow the appropriate procedures down the road.
Well, I think. Yeah, please.
So, in my research, I realized that a while back that he owned a piece of property in the old Oxford area. It's very close to where he lives. And I thought it was very interesting that he had purchased that piece of land, but he wasn't going to develop it and do his project there. So I guess you just kind of answered my question that it wasn't allowed to go on. And so he packed up and moved across town, and now it's our problem. So what makes that project here now any different than the project?
Hang on. Before we go down that road, it's site specific. Okay, so understand your question, but we did. We did.
It's the same complaints, it's the same issues.
But we put, and I'm going back off memory, so don't hold me to this. Okay, so
I'm sure there's minutes somewhere that can be.
there are minutes. We put restrictions on him to have certain guidelines, and he met those guidelines by purchasing this property. We didn't know where that property was, had no idea, but he met those guidelines by purchasing that property. Fair?
Yes, sir.
Okay, so that's off memory, which, forgive me, because that was probably a year ago. So it's been a while, but I remember that one. All right, because I'm looking at everybody that was here hoping I'm right. All right, so I remember that one.
I think we have one that has.
I think that, oh, I'm sorry. I ignored you like twice. I'm sorry. All right, you must be married. Congratulations.
My name's Keith Roark. I live at 100 Belvedere, which is directly across from Robinson Lane and this property site. So where all these folks look at it from down the creek side, I get an overhead view. And first of all, I didn't know what was going on. I apologize for not attending the other meetings. I'm just now getting into this. Had a lot of medical issues with my daughter that we've had to deal with. But I do credit these guys for the old building they did. They kind of renovated it, cleaned it up, looked really great. I was told that it was going to be a conditional use property for landscaping business. Obviously, any business that's going to start up, they're going to have, it's going to take time to get the property and everything in order to operate. But I was seeing a few pieces of equipment. Now, my view over this property used to be a very serene look. Beautiful property, right into the creek, lots and lots of deer running through that property. I just enjoyed sitting out there at night and drinking coffee. Deer are no longer there. I don't see them. And the vehicles have continued to grow. Now, my question is, if you permit a business on this property, all businesses, the idea is to grow. That's going to grow more equipment, more supplies. What are the limitations going to be on this property? Who decides that, and who's going to monitor that? And as far as plants coming in from outside of Scott County, who's going to monitor that? I mean, I have a lung disease called sarcoidosis. My daughter has a chronic cough due to her health situation. And if there's no restrictions, as Charlie was referring to, on burning, you're basically given a permit to open an open chimney that can burn 24/7 all year long. If you allow every single home, every business that gets their landscape done to be burned on that site, there's going to be smoke all the time. Now, as far as the flames, yeah, unless you guys were in the building or floating in the creek or sitting down there, I saw no one down there monitoring a fire. That fire burned, I mean, it would burn hot and then smolder. And I sit on my back patio a lot. I didn't see anybody down there. Doesn't mean they weren't there, but I didn't see them. But, I think before this can be pursued, and I think just like building a home, we have to go to building, planning, make sure that we're in alignment with the codes, keeping everything moving forward in that. And I think if there's been restrictions and guidelines, those guidelines need to be done before you move on. Now, I know that business is already going. As far as I've heard 4:30, I'm assuming that's not the time they're supposed to leave the property. That's just, nothing's supposed to be active. But I'm out there 6:30, 7 o'clock at night, and all of the employee cars are still parked over there. So they're working late hours, and I get it. I did landscaping years ago. You work late hours. You can't always quit at 4:30 and go home. But for, basically all the neighbors up and down that area, and I know that Zoe lives very close to this property, they're just, I think what a lot of us are concerned about is the actual view. For me, it went from the field and the wildlife to now what looks like a state parking garage out there. I was told in the beginning that the parking lot was going to be in the back of the building. The vehicles would got to be out of sight, but I mean, they do park them in an orderly fashion, but they're all over the place. So I'm not really sure where we're going with this, but I know that the fire is definitely a concern because if it burns also, who's to say that if wind doesn't hit it and it blows, then you start a wildfire up and down that creek and in that area over there. There's a lot of homes close to that property. Mm-hmm. But like I said, I'm kind of uneducated on it right now, so that's as far as I'll go. But I don't wish to keep anybody from creating a business and building a lifestyle. But in doing so, this was a very quiet area, very serene area, and it's no longer that. Like I said, it's just like a big parking lot out there now. Yep. Thanks for your time.
By the way, you have the prettiest grass in Scott County, just to let you know.
My son knows that.
Yeah. I was mad at KU for going through your yard, if that tells you anything. So, you asked the question, where are we going with this? Yeah. I think that's what we got to figure out. I like Charlie's recommendations of narrowing the scope of the recommendations from the staff. And I think there are some main concerns here this evening that we can at least attempt to hammer out to come to some conclusion. And not that we all want to be here any time, but we have to start somewhere, right? So we have to build to that area. The first one I think is the easiest to address for me would be the number 10, recommendation, which is the plantings, okay, which is the site guidelines. That's the easiest one for me to address currently. I do agree that the fall is probably the easiest time, and most of you guys are shaking your head yes, and so are you. So I do agree with that, because whatever we plant, we want to live, right? You don't want to plant them and then they die. And I agree that probably the fall and the bundle time is the easiest way to get them. I don't want to have to see you spend any more money than you have to. I think we all agree on that. I think the easiest thing, and this is just a recommendation, it's not set in stone yet, but I'm talking out loud. I think the easiest thing would be to put a time limit on when that can be done, okay? It automatically in my head says Halloween, October 31st, okay? Because that gives August, September into October in order to get those planted, and that would help with you guys as well coming into the fall, okay? I'm looking at the head shaking up and down, yes, from some sides, and some are fair, all right? So that one is the easiest one. Here comes the hardest one, which is the burn pile, okay? Or the debris pile, if you will. Charlie referenced it. Mr. Woodall, I think you have referenced it a couple of times. There is a statute that we know, I just can't reference it offhand, about waste on the property from the state level. I can't reference it. Charlie, I was hoping you can. None of us can.
There is. It's just it's a question of whether this is construed by Energy and Environment as an open dump site. I would argue it's not going to be.
I figured that would be your argument.
But we can
It's
define
just
it.
because looking across this county and any other, you don't see those enforcement actions.
Understood.
Because they're not enforcing it. I say if they're not enforcing it, it's an interpretation issue. It's not just because they're turning a blind eye.
Understood. And I would come back to that and say if one person gets away with it, doesn't mean everybody should. Okay?
It's a policy.
It's a policy. Yeah.
By that agency. But I would also say, if, let's say we had a burn condition for, and it's the first time he burns, the building inspector goes out there, or someone from the environment county comes out and says, gives them citation. Well, that's a direct violation of the conditions. So it's probably going to be back here if that were to happen.
I'm sure.
So I guess what I'm saying is it's not to me, that's not a board. The board's not condoning anything by authorizing a condition to burn or have a brush pile. That's where the enforcement.
It is. But we have to set a precedence of something. I mean, it's.
We cannot have an illegal.
No, we don't have a legal opinion in it. I mean, it's, Charlie?
I'm sorry.
On the burn, I think what we could do is state what you said earlier. If it originates, it has to be burned.
And I think that, well, first of all, we don't have authority to say it's okay to burn debris you bring in. It's also not our authority to say you can't burn what's developed on site.
Right.
Because both those are allowed by state law. What I don't want us to do is to, either because it's too generic or certainly not to do it specifically, is to say, that's fine, keep burning stuff from someplace else and bring it on in.
Right.
We can't, I just don't think we should do that. Not because that would then make it legal, it certainly wouldn't. But we shouldn't be misleading either neighbors or applicants that somehow we're condoning something that we cannot condone. And even if we could, we really probably shouldn't.
You're right. In saying that, I think we understand, though, that that is in the floodplain. The pile right now is in the floodplain, no doubt about it. So it has to be moved. Yeah, yeah, you're probably going to chase it all around the property, I'm sure. The problem is the floodplain goes all the way up to the back of your building, just about. If you'll put the floodplain back up, so then it becomes.
Floodplain go pretty much to the back of the building?
Yeah.
I thought it went inside of the building a little bit.
If you, it catches the corner of the building,
Yes.
so then it becomes, where do we put it?
Part of the difference is, since I was notified by Mr. Kane about the burn, I started just to accumulate, because I didn't know what to do. If we had some type of restriction, maybe once a month or whatever, 2 months, this would be kept to a minimum. Maybe as big as 2 tables put together, fire would last an hour, and I could put it out. The problem is, when I burned it 2 times, there was an existing pile, didn't know what was in there, assumed it was all brush. Apparently with the explosions, it wasn't. I didn't hear them. But the additional material that came out of the barn, when I demoed it, I had to put that in there. So yes, it did grow. But if we were to come up with some agreement of a size of the burn or burn once a month, it wouldn't get lead. It's gotten that big as I
do
Joe
it
King.
outside material.
Quite frankly.
I don't know how this is possible. The man is very gentle and touch. He's very,
He's a pussycat with us, but he's hell with those guys.
I guess he is. I guess he is. 15 years of leadership.
Does our trash people run, do they have a site that you can take and actually dump it like a recycling place?
I don't know if they take debris, but they do have one over there by the pilot.
I was just wondering.
Yeah.
I have no idea, to answer your question. I don't know.
Oh, they do take debris.
Are they the ones that had that big transfer station over?
Yeah. Yes.
I believe the neighbors took that.
The thing is, as time goes, it's gonna become more and more of an issue for the landscapers that are burning out, like, I hate to say fake, I mean, the stone, but I mean, they don't require, they don't allow burning period without permits, and they have that place over there with, old Frankfurt now, I think it's gone, but
Yeah,
they're all around, yeah, it's gone. I don't know if
Yeah.
that's the direction you eventually need to go. It'd be an incredible expense for you to
Yeah.
do that.
Well, and like
Start that
some
business.
landscape alternatives, they don't do that.
I'm sorry, say it again.
I got some landscape alternatives, you know, they're different. Well, they're able to burn. Stuff like that.
They cannot burn off-site materials. They cannot. And they know that they cannot because I spoke with the owner today.
They do.
Not
Irregardless.
off-site materials.
I'm not getting into other landscapers in this one. We'll start a firestorm that we really don't want. Yeah, firestorm, bad word, sorry.
So we really can't give
My
him a
bad.
day a month to burn because it would still be outside material.
Again,
The key word is off-site. Yeah.
off-site material.
So what are you generating there to burn? Anything?
At my personal property, all kinds of debris. If I went around and collected everything on my property, it'd be 3 times the size of what's out there now.
That property right there.
Yes.
Well, you're still cleaning it up.
Dead trees.
And into that,
Part of that is barn demolition?
yeah.
What's that?
Did you say part of that is barn demolition?
No, there was some debris in the barn.
Oh, just cleaning out the barn?
Yes.
I get that any cleanup, you know, there's gonna be a lot of cleanup, there's a lot of woods around that property. So I'm assuming that what you're talking about is debris, trees that have fallen on the property, you haven't removed those things. I think what these folks are more concerned with is the long term, just constantly having fires going. Because the way station wouldn't be feasible for you, there's 4 triple in it, I think, per year.
Yeah, there is.
So that leaves you to either burn it on site, which I don't know if you're doing commercial primarily or residential, but if that commercial business doesn't allow you to burn it, then you have no choice. It's got to be removed and taken somewhere. But there again, we're opening up that door, that window where that fire can burn every day. And I get it, he's saying he wants to go once a month or whatever, but
We just don't create that big. We're not trying to grow, we're not trying to create that much debris. If, like I say, if we burn once a month, it may be the size of 2 tables, like right here.
Circle back. Just keep circling.
Was there any other ones we needed to tighten up besides this one? We did the plantings. Can we like?
Well, the floodplain's the easy one. Everything's got to come out of the floodplain. Okay, that's the easy one to do. If it's in the floodplain, it's got to be moved.
I'm also
Okay, so-
concerned about the cars that are there from employees till 6:30 or 7 when we said all employees had to be gone by 4:30.
Thanks.
Condition 12. All employees off at 4:30, only the applicant is allowed on the property.
closer to the road, with the creek being there, we not create a lot of smog for the drivers. And you're saying, pull it up closer to the road, well, that moisture from the creek and smoke together, it's gonna create a smoggy area. Driving around, that curve was just straightened out a few years back because it was such a dangerous area.
Yeah.
Yeah,
Yeah.
but the same smog is right now crawling up the creek into their property.
Anybody else want to be chairman? Just asking. Thanks. No, you cannot. No. The debris pile you have there now, you have to move it out of the floodplain, which means in order to burn it, you're gonna have to move it. Then you're gonna have to move it up close to the road, which is gonna cause a problem. Because everybody, and that's a valid point, I'm just saying, because I've lived on that road for quite some time. You come around through there and it's smoking, down through there, it's gonna be hard visibility-wise. My issue is anything you move towards the road, which is away from the floodplain, may create another issue of line of sight for traffic, which goes through my head. Because if you're burning that big of a burn pile, it's a lot.
Again, they won't be that big.
But this one is.
But even a small one would be in .8 acres on the
Yeah,
road.
separated, you know. You don't have to get all burned at one time.
Anybody?
Well, it's still only the .8 acres on the road that he'll be allowed to burn it. I mean, that's still gonna be on the road.
I'm sorry, excuse me. If, once you get this glut that you've got now, and you say, yeah, a couple of times a month, it wouldn't be much more than a couple of times this table.
Correct.
So basically, in a month's time, 4 of those tables.
Yes.
Why can't you just get one of those god-awful chipping machines and reduce it, whatever you call that stuff?
Mulch?
All chipping machines cost $100,000. Never put me out of business.
Well, you've answered my question.
And what am I doing?
Houston Landscaping.
Well, I will say, and I don't mean to refute you, but the larger the chip pile, the mulch tends to burn. So it smolders during the summertime, and then you got a fire problem anyway. So, oh, everybody's going to look at me. All right, number 10 is solved. You'll put the boundary in by October 31st. Right? I haven't made the motion yet. I'm just stepping through it.
Yeah,
Mr. Chairman, could I propose something
Please.
on this burn issue? We've got the floodplain solved, we've got the planning solved. Could we table the burn situation, come up with a plan, bring it back next month?
If you don't burn in between now and next month.
Okay, sure. Still gotta move the pile out of it.
Still got to move the pile out of the floodplain. I'm looking at the neighbors because I want everybody to agree with this. Not that they have to, but I'd like to get buy-in from people.
Would you like a burn and the smoke coming in your
What's gonna change between now and next month?
Nothing unless they can figure out a way to move it off and
I don't think they can
I was out there
burn.
today, I got a farm in this county, I burn stuff just frequently. I drove around and tried to figure out where everybody lived, no, I wouldn't want smoke in my house. But, I'm also envisioning how big this burn pile is gonna be on a consistent basis, not like right now. And I honestly don't believe it's gonna be a problem. Right now, sir, I fully understand. It's a big darn pile.
The air is damp, the big pile
Yeah,
makes that smolder and smolder. That's what
yeah, I agree. I just think
right now,
it's-
we burn like crazy for a couple hours, half a day.
Well, it depends what material's being brought in. Is it really trying to, like, I noticed last week, part of that now you covered with a bunch of board, looks like wood, heavier wood. That was all like boxwood, dead boxwood and stuff like that, that's gonna, go up pretty quick. But if it's damp, newly cut wood or heavy wet landscaping, it just sits there and just smolders and smolders and smolders.
We had a stump smolder 3 days last week.
Well, as homeowners, we all have little, well, I won't say we all, I know you and I have a little small burn pile. You'll burn a little trash here and there, but I monitor that until it's fully consumed and burned, and then I pour water on it before I leave. And it comes down to a lot of that, and it's more of an integrity thing. Are you gonna monitor that until it goes out? And that small pile, because I'm thinking if you were to burn it midday, when there's not a lot of moisture in the area, and make sure it's totally incinerated and out, it shouldn't create a lot of smoke. But if it's something where you're piling leaves and sticks and everything in there together, that's gonna create a problem.
I agree, one of those first fires had to be like that.
What I,
Short of not burning anything at all, what would you all suggest? Once every month, 2 months, 3 months?
Again,
can we revert back to a couple of things, because there's good discussion had on both sides, and I want to make sure we continue it, because all of us have burn piles. I mean, I live out past, not past you all, but I live out for Longview, towards that way. And so I have a farm out that way, got a burn pile, understand it. You're correct, I have to stand there until it goes out, right? Or the fire department comes out. So understand that, and John Carter would be one of them. I know him well. So understanding that, I agree that 1 month is probably too long. It probably needs to be in multiple settings, so it's a smaller burn, right? I also think when we look at the conditions where the employees have to be there until 4:30, what would stop you from having an employee if you started a burn pile at 8 in the morning, and when most people are working or whatever the case? I know some of you are home, but started a burn pile at 8 o'clock in the morning, have an employee, that's his job, is to make sure he stays right there and monitors that burn pile. By 4:30, I will tell you, has to be put out. I didn't say every day. But I will say smaller burn piles would be better than the inferno that's back there. Okay? We'll have to address that one separately. But I don't want to stop anybody from doing business. Okay? I don't. But I also don't want to be, I don't want to look incognizant to you all either. I know people that live on Robinson Lane, have good friends there. So understand, but I'm trying to meet in both middles here where we have something to do. You have a right to operate your business. You don't have a right to infringe on them, okay, in that manner. So we've established the plannings, we've established the boundaries. I would propose a burning of at least once a week. It has to be out of the floodplain, okay, so it has to be up towards the road somewhere. I would understand that somebody, the development plan would have to say, that's a good place for this, okay? I would recommend that you pass that through the development plan first as to where that burn pile is going to be. You burn once a week, and one of your employees has to stay right there with that fire. They start it early in the morning, and they put it out by 4:30 before they go home. Okay? Make sure it doesn't smolder, doesn't get out of control, anything like that.
Is this
Fair?
off-site material?
No, we cannot.
No, we have to specify that, though. No off-site material, only that generated on.
Only the material generated on your property would be able to be burnt there. But bear in mind, if that's the statute, or if that's the ordinance or the recommendation that's put in, you all would have a right, if that's not what's happening, to come right back. And to Charlie's point, Joe would issue an enforcement letter at that point, which we don't have. Okay? We have a letter. It's not an enforcement letter. Fair? What we have is basically people said, hey, make some recommendations. That's what we're trying to come to today, is the recommendations. Once we reach that recommendation stage, it can go to the next stage if you don't comply with the recommendations. Fair? All right.
So you're recommending at this point that the only thing that is burned is debris off that property?
Yes, sir.
I mean, that should definitely limit.
It should.
Can I ask a question? Mr. Chairman, I have a question.
Yes, please.
As I said before, I don't want us in any way to condone violating state law. But we also have to realize there's stuff on site right now that is not created on that site.
Correct.
And I don't think we're going to sit here and say, segregate the on-site from the off-site. But we need to get rid of what's there. And once that's gone, then we have a baseline, and then everybody knows what to anticipate thereafter. But what's there now needs to go, without officially saying burn it.
Right.
Site, but that's got to go. And because otherwise, I mean, in effect, we allowed that to be there, and I think we need to.
I think I would propose at that point to break up the pile that's there into much smaller. It has to come out of the floodplain anyway. The way to bring it out of the floodplain is to bring it into smaller piles, burn it in smaller piles, get rid of the main one that's there, and let's start with a baseline. The proposal on the baseline would be only the stuff that's generated on that property is what's burnt on that property. Out of the floodplain, everything else that you generate in the landscaping business has to be burnt wherever you generate it.
Quick question, Charlie. One of the regs of statute you're citing has to do with prohibitions without a permit. So if you were to obtain a statewide permit.
That is true. Yes.
Fair. The state overrides us anyway in that aspect.
Well, yeah, once they do that, it's totally out of our hands regardless. But I think that is correct, that without a state permit. Now, I don't know what the conditions are that must be met to get that permit,
Right.
but we don't have one now. But that is at least a legal possibility.
You
That's
wanna
fair.
set the day? You wanna say once a week or set the day?
Once a week? Okay, I'm looking, I'm scanning the room, so, once a week?
We're gonna break down what's there, so that it can be burned in smaller piles, fully attended, start to finish, out of the floodplain. Right now, we're under a restriction of only thing that can be burned other than that particular pile. Going forward is what's generated on the property.
Correct.
Understanding that we may obtain a permit to do otherwise, to bring material in.
Yeah, that would be on you all at that point.
When you're burning once a week.
As of right
Still,
now,
it doesn't matter, still burning, yeah.
Yes.
as of right now, you agree that you will not bring anything from other sites on your property.
Let's just put it in the form of a motion, that way it can be enforced.
Nothing can be brought in.
As, yeah.
Well, that's with the.
As of
state.
right now, you don't, so,
Right.
as of today, okay. So I'm gonna, do we need a motion? I guess we need a motion to add these, okay. So I'm gonna attempt to do this, I need to make a motion, I think. So I'm gonna make a,
Not being recorded, right? Our recording is this?
all right,
That's what I'm afraid of. All right, go ahead.
all right.
This is Jay's last day.
This is his last day, so he is recording today.
Yeah, he's here.
In that case, have at it.
All right, so I'm gonna make a motion to alter recommendation number 10, or staff recommendation number 10, which deals with the planting and fencing, to have all boundaries in place, planted by October 31st, 2023.
Does that also relate to sightline fencing?
Yes.
So
10 and 11, excuse me. Recommendations 10 and 11, okay? So recommendations 10 and 11, the deadline date will be October 31st, 2023, okay? Forgive me, now I'm lost. Where's the next one? Elise, is it 12? Yes. Number 7, recommendation of number 7, the applicant shall keep all materials, vehicles, a minimum of 50 feet from property boundaries. Got that one. The floodplain. Everything, I'm making the motion that everything has to be moved from the floodplain, out of the floodplain currently, correct?
When's the deadline?
No, we'll put a timeline. Yeah, I think it's right to put a timeline. Well, I'm going to ask the applicant, how long do you think that will take?
Including that bond?
The burn pile?
Everything.
Yeah, anything in
Anything in the
Well,
floodplain.
if I can only burn once a week, that, you all need to tell me how big those piles need to be to burn once per week.
Well, but all of it's got to come out of just.
All of it's got to come out of the floodplain.
Oh, get all out, by 1 week,
Yeah.
fair?
That's vehicles and everything. All vehicles, machine,
Yeah,
machinery,
I think
materials,
that's, I think that's actually pretty aggressive.
Let's go with move.
I think that's pretty aggressive, to be honest with you. I want to be fair when I do this. So I think August 31st,
Sure.
okay, would be fair with that in order to move things. I don't think it's right to say a week. I think that's a little aggressive. So August 31st to move everything out of the floodplain?
Be out of line to suggest, I don't know if the other end of your building, you know where your burn pile is now, back closer to the home, if you were to move, again, I'm telling somebody where to burn on their property, but if you were to move your burn pile to the other end, there's not really a lot of close houses, you know, that smoke is gonna get into.
It's in the floodplain.
Yeah, I'm not home all day, but I know it probably does get smoke on, but would that be a better alternative, even if you're burning?
I understand what you're saying, I just don't know what you're talking about.
Well, you know, if you're coming 460.
Right here. On the right side.
Over here?
I can't see you building
About right as you can get.
from here.
You talking about right here?
So you're telling me this is your building?
Yes. No, that helps.
White building.
White building, okay, white building. So instead of being down here, which affects all of these homes, bring it over back toward. Wrong direction? I just had eye surgery, so forgive me. Yeah, okay, so on the further end away from Robinson.
Yeah, and it's, the property next to mine is so grown up, and it's
I was thinking further away from Robinson Lane along the creek side.
So we're gonna give them a deadline on this big push, but I want them to burn more frequently, just to get it done.
He's got August 31st now.
that spot would be.
So that falls
Can we
into
do
that.
that In 3 weeks?
Oh, yeah.
in here. Would you agree?
I think it would be best to keep it away from the property as far as, away from these folks as far as possible.
Just out of the floodplain?
Out of the floodplain, just please out of the floodplain. And don't worry, if it gets out of control, Frankfurt Road will all know it. Yeah.
This isn't the sign plan, so their development is, Robinson's this way.
Yeah.
So town's that way. So this area, this is the floodplain line.
Which one is it? This is the floodplain, right?
So he can't, to this side of the building.
Build line.
That's what I'm thinking right here.
Right
Is,
here.
yeah. Anywhere over in here, I don't want him right up on the road with a burn pile, but
This is technically within 50 feet of the build line. If you want, we can consider something that's like 25 feet from property line or something like that. And to be like for the burn except for this one.
Moving forward, where would the other once a week be though?
I think it would.
Over here?
No, I think it would.
Always
I think it
right
needs
there.
to stay down here. I think it needs to stay in this area.
Can you give him guidelines to go ahead and make a motion and designate that?
Let me talk to Charlie about it. Okay.
Yeah, go ahead and designate exactly where. That's what I'm saying. Let's not put this off. Let's just be done.
Yeah. I'm trying. Give me a minute.
I thought you were short.
Don't you ever forget.
What's the next one that has to be made?
Well, I think that's all of them, isn't it?
Is that all of them?
We gotta do, like, if you told them August 31st to move everything, we didn't say burn everything, we said move
Move it,
everything.
right.
And then we have to say, we're gonna give a specific day of the week, or just say once a week, and who's gonna monitor that?
Okay, yeah.
And then you need to make sure it's what, between 8 and 4:30? Like you said, with an employee there, all that has to be put in motion, yeah.
Oh, yeah.
That's perfect.
All right. I got one other one.
And then you can have the spot
Yeah.
based on her.
I just
We're
got
looking
one
at the spot or where to burn. Hang on a second. It's gonna be easier if we can just absolutely state,
I want to get this knocked out tonight, and
yeah.
as much as you don't want to see us, we don't want to see you either, so, you know.
Go away and do your business.
50 foot from the boundary?
We don't want it up, in the right of way.
Right.
So it's out of the right of way, out of the floodplain, as far east as you can get it.
All right, so going over where, if I can grab your attention just for a second, going over where we're talking about the actual burn pile, okay? Going over where we're talking about the actual burn pile. What we want to talk about first is the big pile he has currently that's there. Obviously, that's going to be burnt in sections. He has up to August 31st to do that. The way we want to state that is the burn pile would be located out of the right-of-way, okay, out of the right-of-way, as far east as he can get it, out of the right-of-way. So we don't want you in the road right-of-way, okay, so out of the right-of-way, as far east as you can possibly get it, outside the floodplain. Fair? Does that work? 'Cause that's farther away from you all, down the creek line, actually, is the way it would be. It'd be in that corner up here, which was, I believe, what you were suggesting earlier. Okay, yeah. Yeah, you were in the other backyard, so we don't want to do that. We don't want to be in your backyard.
Will he be bound by burn bans?
Oh, yes, absolutely. That is a county, state, yeah.
You have to call in every burn, so.
Yeah, absolutely. Okay, so that's in the motion. You got that, right? Okay. The last motion that we have is the burn pile once a week. Okay, that we're going to add a recommendation that we burn each pile once per week. I'm not sure whether I'm not going to set a day on it, Monday through Friday. I don't think that's fair depending on what your work schedule is. I can't put a day on it. But it has to be in your operating hours between, I believe it's 8 and 4:30. It has to have an employee or yourself with it 100% of the time, and has to be put out before they leave, completely put out before they leave. Make sense? No.
So if he doesn't have accumulation,
He doesn't have it.
Yeah, if there's nothing to burn, don't burn. I mean, it's, yeah. It needs to be completely put out with water.
No
How's that?
smoldering.
No smoldering. Yeah. That's just off, that's just the, yes, included in that motion is just the items that are generated from that property to be burnt.
And that's after what's there now is
Yes.
gone.
The current pile can go away.
So you're gonna see for the next 2 or 3 weeks, there will have to be some disposal.
Yeah, fair? All right. I'm not going to repeat those motions because it took me long enough to make them. But the burns would have to be put out by 4:30 by an employee or himself via water. Okay, fair? All right. That will need a second on all that.
Second.
Rachel seconds the motion. Any questions or comments from the board? All in favor by saying aye?
Aye.
All opposed by the same? There are none. Motion carries. Okay? Any other business we need to have tonight?
No.
Good.
Did you already implement the 12, part 12 with the hours?
The sight line? Or the hours?
Of operation?
Well, I included it in the 4:30 with the burn because it stated that they have to be out by 4:30. So it's still there. Okay. All right, and you're clear on that as well?
Yes.
All right, in that case, I'm done. Meeting adjourned, 7:20. I'm out.